Up to four, my lord, I have only pointed out. This is the skeleton on which, my lord, I'll address your lordship. Lord, 26th of July 24, a show cause notice dated 26th July 24, which is placed by, my lord, the petitioner at annexure C, was issued to the petitioner in relation to the petition seeking grant of approval for investigation on the basis of complaint filed by respondent number 3. Lord, it is an admitted position that what is
going to be even this
the content of the show cause notice is only the complaint of respondent number 3 and not the other two complaints.
Gives no cause of
Because my submission is going to be even this step was not necessary. Therefore, non-compliance with other two makes no difference, creates no prejudice, gives no cause of action. Then, my lord, on 31st of July 24, a cabinet note was put up for consideration of the Council of Ministers in relation to the show cause notice issued by the Honorable Governor of Karnataka to the Honorable Chief Minister to respond within 7 days.
As to why sanction for prosecution should not be granted, as requested by one Sri T.J. Abraham in his application dated 26 July 24. The cabinet note in its introductory paragraph
of the cabinet dated so and so.
Respondent
and
number two
reply
placed
of
the
the
file
petitioner
in
dated
relation
so
to
and
the
so
issue at
before
hand,
the honorable
along with
governor.
the decision of
respondent
the
number
cabinet
two
dated
is
so
the
and so,
secretary to the
and
honorable
reply
governor.
of the petitioner
Lord, whom
dated
I
so and so
represent
before the
and
honorable governor. The
he
respondent number
placed
two
that
is
these
the
are the
secretary to
papers.
the honorable
This
governor.
is the note of
Lord, whom
cabinet.
I represent.
The cabinet has to
and
say this, and
he
all
placed
documents.
that these are the papers.
As I will
This is
show
the
from
note
the
of
file. Complaints, documentary evidence is annexed with the complaint, etc., my lord. The opinion of the learned advocate general, everything was placed. Then, 8/8/24, the Honorable Governor directed respondent number two to put up the file along with comparative statements of the petitioners. Petition, my lord, he understands, my lord, to be complaints.
Oh, this was done.
Yes, my lord. Well, there is an elaborate application of mine. I'll show from the file. I'll share it with my learned friend. The Honorable Governor directed respondent number two, that is his principal
Yes.
secretary, to put up the file along with comparative statements of the petitions received in relation to the grant of sanction, reply of the chief minister, and the decision of the cabinet. That you give me in this format, then I'll make up my mind. Then 14th August, comparative statements as referred above were placed before the Honorable Governor for his perusal. 14th August 24, after perusing the file and discussing the issues, the Honorable Governor directed to resubmit the file along with notes or analysis points as dictated. The learned governor dictates that this is the allegation of the complainant. This is what the cabinet note says. This is what the reply of the Honorable Chief Minister says. And this is the note. The note is dictated by him. I'll place it. It's a big chart, my lord. Several charts were prepared, and the Honorable Governor, my lord, himself dictates. Based on, and this comes, my lord, in the noting file also. It's not that I'm saying for the first time that it was dictated by the governor. In the noting file, my lord, it comes that it was dictated by the governor. Based on the comparative statement and available documents and petitions. The file, along with all the above referred documents and comparative statements as dictated by the Honorable Governor, was placed before the Honorable Governor for necessary orders. The order of approval for investigation was passed by the Honorable Governor, and, my lord, thereafter, my lord, the petitioner is before your lordships. Now, my lord, taking the first point first. Lord, your lordships are aware, prior to, my lord, the enactment of the new Prevention of Corruption Act,
Yes.
the amendment to the Prevention of Corruption Act, my lord, which was in
26/7/2018.
yes, my lord, 18, there was no concept of an approval prior to
Yes.
the investigation. The only concept was pre-cognizance sanction
Sanction.
under section 19. My lord, for the first time, 17A comes. My lord, your lordships have read and reread this provision, but only read kindly, my lord, on my request,
Yes.
page 8, page 8, only subsection 1.
Yes, sir.
No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act. It doesn't talk of BNS or IPC. Under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous sanction of ABCD. My lord, according to me, this case would fall within B and C, but I'll have to independently substantiate that it is the governor in case of the Honorable Chief Minister who is not supposed to act as per the aid and advice of the Council of Ministers. Now, my lord, so far as this is concerned, my lord, I have already pointed out that the scope is very, very limited. I have to, as a governor, see whether the complaint and the documents which are placed makes out a cognizable offence which requires investigation. It may result in a charge sheet or the report under 173 as we call it, or a closure report as per old section 169. But that's not the call the governor is permitted also to take. The governor cannot say that I have examined and cognizable offence is made out. It's of a serious nature. It will be attracting this provision. It will be attracting so much punishment, etc., etc. No, he will go by prima facie case that whether it needs to be examined by an investigating agency as an investigation under the provisions of law. Lord, your lordships have had an occasion to consider, my lord, this honorable court had considered, your lordships, my lord, thereafter, my lord, gave a detailed
Yes.
and illuminating decision. But Sri Rupa,
Yes.
my lord, I would your lordships like me to, my lord, place for your lordship's
Yes.
consideration?
Two very different concepts.
Yes, my lord.
Approval and sanction, they stand on
They
different.
stand on different footing. The parameters are different, the considerations are different, the way in which you deal with the application is also different.
In that case, there was nothing said.
Yes.
Nothing said except saying we grant approval.
Approval.
There was no application of mind at all in that case.
Yes.
That's why that was.
And, my lord, they are relying upon these judgments to show that there has to be an application of mind. My lord, in my respectful submission, to canvass a proposition that any administrative order has to be after application of mind, you don't need any judgment.
It's rudimentary.
It's elementary, my lord. It has to be after application of mind. You don't need any judgment. There are certain, my lord, universal propositions which doesn't need to be supported by any judgment. I'm straightway conceding it has to be after application of mind. It will depend upon facts of each case and what is the extent of application of mind
That
is
case to
relevant.
case basis.
Is based on facts to facts.
Facts.
So, my lord, I am placing it, my lord, but I'm not reading, my lord, this judgment. Lord, kindly see what would be the scope of the power, my lord, because your lordships would be laying down the law in while deciding this. Not only with reference to a scenario where the honorable governor, who is a constitutional functionary, is deciding the approval issue of the honorable chief minister, who is also a constitutional functionary. 17A applies across board.
Yes.
In case of a tehsildar or a patwari, maybe the tehsildar is or deputy collector is the authority under 17A.
17A.
So, what is the scope of his inquiry? What is the scope of his application of mind? Whether to exercise 17A power as requested by the complainant or not to exercise. Lord, that broadly, in my respectful submission, we can get assistance, my lord, from Lalita Kumari Judge.
Yes.
That your lordship would find at page 12. My lord, I can take your tell your lordship, my lord, whatever paragraphs I have quoted,
It's quoted.
I have, my lord, the full text of the judgment, which
Yes.
I'll place.
Yes.
But this is only for ready reference.
Yes.
I'll place, my lord, the entire bunch, my lord, for your lordship's consideration.
Yes.
Right now, my lord, I'm not giving.
Yes.
My lord, please come, my lord. This is your lordships are aware it's a constitution
Yes.
bench. 5 honorable judges, my lord. 31.
Yes.
And I'll skip some of the paras, my lord. The FIR is a pertinent document in the criminal law procedure of our country, and its main object from the point of view of the informant is to set the criminal law in motion, and from the point of view of the investigating authorities is to obtain information about the alleged criminal activity so as to be able to take suitable steps to trace and to bring to book the guilty. Now, kindly come to page 30, para 49. I'll skipping, my lord, other paragraphs.
Yes.
49, highlighted bold part. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information, and that information must disclose a cognizable offense. This applies squarely to 17A. If any information disclosing a cognizable offense is led before an officer in charge of the police station, someone has forgotten, my lord.
These things happen.
Yeah, these are, my lord, some interesting incidents in the virtual hearing.
They are the
Must disclose a cognizable offense. If any information disclosing a cognizable offense is led before an officer in charge of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in the prescribed format, that is to say, to register a case on the basis of such information. Lord, I am not comparing the police officer with the governor, but I am saying police officers' function under 154 is the function of any approving authority under section 17A. He may be a tehsildar or he may be the honorable governor. That whether prima facie offense is made out then not only he is duty bound, it is not only his right, he is duty bound to accord approval. The provision of 154 of the code is mandatory and the officer concerned is duty bound to register the case on the basis of information disclosing a cognizable offense. Thus, the plain words of section 154(1) of the code have to be given their literal meaning. The use of the word shall in 154 of the code clearly shows the legislative intent that it is mandatory to register an FIR if the information given to the police discloses the commission of a cognizable offense. Therefore, the context in which the word shall appears in section 154(1), the object for which it has been used, and the consequences that will follow from the infringement of direction to register FIRs, all these factors clearly show that the word shall used in 154(1) needs to be given its ordinary meaning, etc. My lords. My lord, my learned friend may be tempted to say that in case of 17A, it is not shall. The shall is used only with regard to the police officer and not the governor.
Yes.
I am using this judgment, my lord, for assisting your lordships to say that these are the parameters the governor will bear in mind. That I am not supposed to conduct a trial. I am not supposed to even examine whether I would ultimately give sanction for section 19.
No, it is at stage of 17.
70.
So it's one.
Because section 19, he would be having the material
Yes.
filed by the police and his parameters would be again different. The threshold would be high.
This is only prima facie.
This is only prima facie. If there is a cognizable offense made out, he has to give approval, whether he is governor or a tehsildar. Yes. ma'am. The only exception, my lord, in Lalita Kumari is that in case of Prevention of Corruption Act or matrimonial offences, conduct a kind of a preliminary inquiry. That is for the police officer. Here, he has to apply his mind. Preliminary inquiry does not mean
6 clauses in para 20.1, 120.1.
120.1.
Yes.
So here, my lord, he is conducting a preliminary inquiry within his mind that it is whether case is made out or not. My lord, why I say this, my lord, what will be the disastrous consequence if we read, my lord, the principles of natural justice into it? As I said, my lord, it's not a case of Honorable Governor and the Honorable Chief Minister. This would apply to all public servants under the Prevention of Corruption Act. In many cases,
So if I can, so the suggestion is, if natural justice is to prevail prior to 17A, and you're paraphrasing 17A to 154, then before registration of FIR, notice will have to be given heard.
exactly.
That will
My
have-
learned friend, in
it would
fact,
be-
cited, my learned friend, in fact,
That is what you're
cited
trying to.
Rajesh
Yes.
Agarwal judgment,
Yes.
where he said that he had an honor to assist the Honorable Court. I incidentally also had an honor to assist the Honorable Court, where my learned friend inadvertently missed that part where the Honorable Court said that in criminal matters, hearing is not required in that very judgment. Otherwise, my lord, kindly see the
Otherwise,
consequence.
prior to 154(1), every accused will have to be heard. Now, of course, in the new BNS under 218, and it's pre-cognizant stage, yes, a notice is required.
No, even there, the Supreme Court says not required.
Yes.
As perhaps my learned friend was on VC, it missed out. I said the argument was that to declare account fraud is like an FIR. So how can you hear before an FIR? The court made the distinction that no hearing is required before FIR. But to declare an account fraud, which is akin to criminal, you must have a hearing. That is the distinction I made. Perhaps you missed it on the VC.
My lord,
Yes,
kindly, my lord, consider if my learned friend is right that before granting approval under 17A, a hearing is required. 17A is for the prevention of corruption offences. It applies over the board
Yes.
to every public servant.
Yes.
The moment, my lord, notice is given, there are all possibilities, my lord, that the evidence will be lost. That is one more reason, my lord, not to read hearing or principles of natural justice under 17A. Suppose, my lord, a collector were to give approval for the deputy collector's corruption case and he is in office. He might, my lord, tamper with the evidence. He might misplace the file. The evidence will go. This is one more reason why 154 or 17A, no hearing.
Except the preliminary inquiry that is in 120.1 of Lalita.
Yes, my lord, in a given case, in Lalita Kumari says, my lord, that if it is something, lord, suppose I go and file a FIR which is completely absurd, that Mr. So-and-so I approached and he demanded 50,000 rupees. Then straightway don't register an FIR and pick him up, conduct a kind of a preliminary inquiry because it's the station house officer who does this.
Yes.
While here in 17A, why that preliminary inquiry is also not contemplated. Only contemplation is whether you find cognizable offense being made out from the material on record. So merely because the Honorable Governor thought it fit to issue notice in one case does not necessarily mean that non-issuance of notice in other two
Will
cases
vitiate the proceeding.
would vitiate the order. Now, my lord, I am relying upon at page 14, my lord's, my lord, very illuminating judgment, my lord, in Dr. Ashok versus the state, where your lordships were pleased to
Yes.
my lord, distinguish.
17.
And I think this is the first judgment, my lord,
Yes.
juxtaposing 17A and 19, my lord.
Yes.
And, my lord, your lordships were based upon that judgment, my lord. There is a direction also issued, my lord, by the
High Court.
High Court, my lord,
Yes.
that even it applies to the magistrates. The magistrate also cannot straightway issue process or call upon the complainant to be in the witness box, etc. The complainant will have to go with 17A. So, my lord, I'm not reading, my lord,
Yes,
Dr.
yes.
Ashok, my lord, it is your lordship's judgment,
Yes.
my lord. Now I will show, my lord, how there is an application of mine.
Huh.
My lord, kindly have, my lord, the original file. I'll share it with my learned friend, Mr. Singhvi, and Professor Ravi Kumar also, but I'll have one more copy. You have copies? And the learned advocate general also, my lord, by virtue of his office, though he is not concerned with the
Get it, get it.
list between, my lord, the Honorable Governor and Honorable Chief Minister, but I understand his position, my lord. And by virtue of his office, he is entitled to have the access. Huh? He is rightly sitting on our side, my lord. My lord, government is always on the some, my lord, honorable in High Court. Honorable Judge asked me, in Gujarat also, my lord, the government sits on the left.
Yes.
That why does the government sits on the left? I said we always sit on the right side of law.
Yes, sir.
I'll share the
This-
original
this is
file.
the
Which are,
entire file.
this is original.
Yes,
Lord, I have shared the original file with your lordships.
Yes, sir.
And obviously, my lord, I am getting, giving Xerox to my learned friends. And I can assure your lordships,
I'll hold this with me.
certainly, my lord, your lordships can
Yes.
only, my lord, ensure that it doesn't go
No, no,
out.
That's,
And I would request my learned friends also that that can remain only with them and their clients. It may not travel beyond. Nothing is secret, confidential, or anything which needs to be hidden, but there is some sanctity attached to the governor's
Office, to the
office.
office.
Madam. And I am, my lord, at the cost of repetition, maintaining that this is without making it a precedent.
yes.
Just to show that there is nothing to hide, A, and two, there is always, there is an application of mine, according to me, more than what was required. My lord, your lordships are not supposed to go through the entire bulk. Please see, my lord, the first part, which is, my lord, the noting section.
Noting section.
This is the noting section. You have the, give it to the AG. Yes. My lord, this is the note, page 1. Your lordship would find it is continuously paginated
Yes.
and paragraphed throughout till the decision is taken.
Yes.
My lord, this is the note placed by the, my lord, principal secretary to the governor for consideration of the governor. I will not read it, my lord. It merely reproduces para 1. Kindly peruse the petition submitted by Sri T.J. Abraham, dated so-and-so, placed in the file. Then, my lord, what is the content he mentions? And eventually, my lord, he writes, please peruse papers. He requests the Honorable Governor. The complaint and addendum submitted by Sri T.J. Abraham may be perused in file. He has requested sanction of prosecution against the sitting chief minister under various provisions quoted so and so. With this fact, the file is submitted for further orders. Now, my lord, the honorable governor on page 3 and note number 8 makes this note. I have heard Sri T.J. Abraham in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view that there might be irregularities and misuse of power. He doesn't reach a conclusion of criminal offense, but he took care to see that there is genuinely a person. It's not an anonymous kind of a, or a pseudonymous kind of a complaint.
Because the complainant himself has appeared.
It has appeared, he was heard, he shown the documents, etc. Hence, issue show cause notice to Sri so-and-so, calling explanation within 7 days. Thereafter, my lord, kindly come to page 5. Lord, it further goes on. As per the order of the Honorable Governor, draft copy of the later, my lord, that is draft copy of the show cause notice, my lord.
Yes.
Then the show cause notice goes.
Yes.
Please come to page 7. Lord, again, the Special Secretary to the Governor writes, kindly peruse the letter dated 3rd August 24 received from Sri so-and-so and letter dated so-and-so received from the Chief Secretary to Government placed in the file. The Chief Secretary has submitted the Cabinet decision dated so-and-so along with the enclosures. The Cabinet note is of 91 pages, but possibly the longest Cabinet note in the history of this country after or even pre-independence. And something more interesting, I'll, my lord, show to your lordships. Pages, along with relevant copies of the judgments and legal opinion in reply to the show cause notice dated so-and-so issued by the Honorable Chief Minister. Further, so-and-so has submitted his reply to the show cause notice dated so-and-so along with legal opinion and relevant records, which runs through 60 plus odd pages. The State Cabinet, for the facts and reasons mentioned in the Cabinet decision, has strongly advised the Honorable Governor, not just an advice, it's a strong advice to the Governor to withdraw the notice dated so-and-so issued to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham and to proceed forthwith to reject the said application by denying prior approval. The Honorable Chief Minister in his reply has requested to peruse his reply as well as the advice rendered by the Cabinet with its resolution dated so-and-so and to withdraw the notice issued to him and to deny prior approval and sanction sought by the petitioner by rejecting his application. With the above details and along with records submitted, the file is placed before the Honorable for kind perusal and orders. My lord, these are the documents submitted by Mr. Abraham as well as by the government. Then, my lord, at the foot is the note by the note by the Honorable Governor, put up along with comparative statements of petitions, Chief Minister's reply, and the Cabinet decision. Put it in 3 different compartments, which your lordship would find. Your lordship need not read it, just, my lord, for the flavor of it. My lord, page 1236. No, I'm sorry, my lord, it is 1224, my lord. There are 3 or 4, my lord, A3 type chart prepared. Just, my lord, have by way of an example, 1224. Well, there is a chart, my lord, of this size. It would be easier to find. My lord.
Yes, yes.
1224.
Yes.
There are 3 columns. Petition of Sri T.J. Abraham.
Yes.
Then specific rebuttal of allegations in the application for approval or sanction.
Yes.
And factual metrics.
Yes.
Lord, similarly, if your lordship goes through the other chart, and I'll my lord, show Cabinet reply and CM's reply.
Yes.
Which is, my lord, the second chart at page 1208. Then comparative statement of all the 3 petitions.
Yes.
This is where the governor comes to know that they are relating to the same transaction.
Yes.
So I need not follow even an empty formality of issuing notices. The allegations are same with respect to the same land, etc. Now kindly come back, my lord, with me to the noting section. Your lordships may kindly come to page 8 now of the file noting section.
Yes. Yes.
21, my lord, para number 21. The file notings are I seriatim numbered and paginated. As directed at para 20, comparative statement of petition received from so-and-so, and the Honorable Chief Minister reply and the cabinet decision are placed in the file for kind perusal of the Honorable Court. Now, please see 22 is very, very important, my lords. This is the Honorable Governor's noting. Peruse the file, discuss the issues. He discusses the issues with the officials, my lord, who are assisting him. Hence, resubmit the file along with notes, analysis points as dictated. My lord, he goes through these charts and dictates at page 1236 his own prima facie conclusions. My lord, page 1236, allegation, reply, and the third column is what is dictated by the Honorable Governor. It is from page 1236 to 1225. So page numbering is reversed, my lord, as your lordship, sir.
Yeah, that is the government files.
Government files. So, my lord, each and every allegation, the reply of the Honorable Chief Minister and Cabinet, he considers and he dictates that this appears to be the prima facie situation. Then, my lord, para 9, page 9. This is, my lord, by the Special Secretary to the Governor. Pre-paras may kindly be perused. The petition received from, then 3 numbers, requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practice adopted by so-and-so.
Yes.
This is the language used in the complaint. He doesn't say that we are dealing with sanction for prosecution. He is reproducing the language of the complainants.
Yes.
Then 26, as directed, the file along with the above details, documents and comparative statements, please note, dictated notes by the Honorable. That is Honorable Governor. That appears to be the way in which the Honorable Governor is referred to within the office.
Yes.
Is placed before the Honorable for further necessary orders. Then, my lord, page 11. Petitions received from Sri T.J. Abraham. My lord, this is the note, my lord, prepared by the Honorable Governor. It is signed, my lord, at page 25
Yes.
by the Honorable Governor.
Yes.
Petitions received from Sri so-and-so, and petition with additional documentation, petition from Sri so-and-so, requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practices adopted by so-and-so, concerning allotment of alternative site by MUDA under various sections of PC Act and BNSS Act has been perused. He reproduces what the complainant say. He doesn't say, I am dealing with sanction prosecution. In view of the allegations and on a prima facie perusal of the petitions for grant of sanction for prosecution and materials in support of the allegations, a show cause notice dated so-and-so along with the copy of the petition by Sri T.J. Abraham and material in support of the allegations was issued to Sri so-and-so. The reply to the show cause notice dated so-and-so along with annexures was received at Office of His Excellency the Governor of Karnataka on so-and-so. It appears from the material annexed to the reply, my lord. I need not read, my lord. It reproduces, my lord, the contents of various things, my lord.
Yes.
Please come to page 15.
Yes.
Or, my lord, at page 16.
That is 31.2.
31.2. The Chief Minister is the head of Council of Ministers. The Council of Ministers is normally required to act fairly and in a bona fide manner. However, the Council of Ministers is appointed on the recommendation of the Chief Minister. So please note here, this is the constitutional mandate under Article 164. 164 requires that the Governor would appoint ministers on the recommendation of the Honorable Chief Minister. This is one of the factors which the Governor considers whether to act on his own discretion or as per the aid and advice. It is but natural that stance of Council of Ministers is in support of the Chief Minister. Hence, in such extraordinary circumstances, it is hard to ascertain that the Council of Ministers have acted fairly and in a bona fide manner. The governor, under Article 163 of the Constitution, is required to act under the said aid and advice of Council of Ministers. However, an exception may arise when consideration is being done for grant of sanction for prosecution of the Chief Minister and the decision of Council of Ministers is affected by apparent bias. As regards the application of doctrine of aid and advice is concerned, this has been conclusively settled in state of Maharashtra versus so-and-so that sanction to prosecute the Chief Minister is the exclusive function of the governor to be exercised by him in his discretion, followed by the decision in case of Dr. J. Jayalalitha versus so-and-so, wherein it was further amplified that it is erroneous to say that the view of the Supreme Court was based on a concession made by counsel, and the perusal of the relevant part of the judgment shows that the court has expressed its opinion that such concession was rightly made. In the present matter, the allegations and the material in support of allegations would prima facie indicate that the said land was given to SC person by due course of law. The record of the said land was transferred from the father to children and again from children to father. This mystery was not considered by the state cabinet. When the notification, now he says why I am not relying upon state cabinet. First he says that even as per law, I am supposed to use my own discretion, not aid and advice. Now he goes further. State cabinet, when the notification for land acquisition issued and the denotification order was issued, Shri so-and-so was the member of Legislative Assembly from so-and-so constituency as well as a member of Mysore Urban Development Authority. And further, this land was purchased by a brother-in-law of Shri so-and-so, wherein the seller was from the constituency of so-and-so, and later on after getting the land converted into the residential purpose, gifted it to the wife of Shri so-and-so, who became the owner of the property, and the application for allocation of alternative sites came to be moved on the basis of relinquishment of agricultural land. On the basis of this application, MUDA passed the resolution pursuant to the amendment to allot alternate sites. It has been specifically averred that the rules was specifically amended, averred in the complaint. He is giving a prima facie consideration whether a cognizable offense is made out, which needs investigation. A rule was specifically amended from 40-60 to 50-50 to aid this transaction where so-and-so was the chief minister. Further, the petition seeking grant of sanction for prosecution and material provided clearly indicate that Sri so-and-so, son of Sri so-and-so, participated in MUDA meeting, which resulted in allotment of alternative site in very prime layout called Vijayanagar. These facts were placed before the Council of Ministers. The aforesaid brief facts, when correlated with the material in support of grant of sanction, clearly establish that there is apparent bias in the decision taken by the Council of Ministers in favor of Sri so-and-so. Due to this apparent bias, the present matter requires my independent application of mind to the petition seeking grant of sanction for prosecution and the material in support of the same. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri so-and-so was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media and newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land and irregularities in allocation of land. Further, the constituting a committee under an IAS officer and immediately constituting one-member committee under a retired judge of the High Court and the government's own acceptance that there is potential big-ticket scam in allotment of sites by MUDA does not inspire much confidence. It is well-settled legal principle that the persons against whom allegations are made should not be empowered to decide the course of action. Even after such grave allegations being involved in the present matter and the fact that materials prima facie supports the allegations, therefore the decision taken by the Council of Ministers is irrational. Well, this is what MP judgment says, that if it is found that it is irrational or vitiated, biased or other considerations I'll come to, my lord, then the governor will have to act at his discretion. as even after the appointment of high-level single-member inquiry committee on such serious allegation, the Council of Ministers do not consider the entire material in support of the allegation. The subject of binding of the advice of the Council of Ministers for Governor and discretionary power of Governor during special circumstances is well discussed and decided in case of Madhya Pradesh Police Establishment versus so-and-so. The five judges bench of the Supreme Court has held that if on these facts and circumstances, the governor cannot act in his own discretion, there would be a complete breakdown of rule of law in as much as it would then be open for governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. If in cases where prima facie is clearly made out, sanction to prosecute high functionaries is refused or withheld, democracy itself will be at stake. This is one quotation from the Supreme Court judgment. It would then lead to a situation where people in power may break the law with impunity, safe in the knowledge that they will not be prosecuted, as requisite sanction will not be granted. On the point raised by the Council of Ministers that an application for previous approval under Section 17A can be made only by police officer and not by a private person. My lord, something which was unfortunately argued by the petitioner, despite, and I will come to that, a very fair and correct legal opinion given by the learned Advocate General saying that no, this is not true. It is not. Any private individual is also,
Yes.
as held by your lordships, bound to approach.
It is only investigation and inquiry should not commence by a police officer without approval.
Exactly, my lord. I am
It is
great.
not that he should seek approval. There is no law that he only should seek approval.
Yes, my lord. But that was
Approval can be sought definitely that's what I have also held. Approval can be sought by anybody. Setting the criminal law into motion, it can be by anybody. So what requires is 17A.
correct.
17A, approval can be sought by the person who has sought to set the criminal law into
Any
motion.
person can
Any
set.
person. No officer shall investigate what is said in 17A is only without approval he shall not investigate.
Even the
He need
court-
not seek.
Where if I, as a private individual, because in a criminal jurisdiction, jurisprudence, there is no concept of locus standi. Anyone
That is-
can.
Anybody can set the
set
criminal
the
law
motion.
into motion.
But if I go before the court invoking, my lord, the powers of the court to issue process or issue a direction akin to the old section 156(3), then I'll need that approval under 17A. Otherwise, even court cannot direct.
That's all. That approval should be there for a police officer to inquire or investigate.
My lord, therefore, my lord, to be very fair, my lord, to the learned Advocate General, in his opinion, he says that, relying upon your lordship's judgment, that no.
That's what
it
I
is-
have myself held.
Yes, my lord, he relies upon, but unfortunately, the petitioner still my lord, continue that no, it can only be the police officer. My lord, therefore, I'm just reading that even that is considered by the Honorable Governor. Provides the police officer and not private person. Section 17A of the Prevention of Corruption Act provides that no inquiry or investigation shall be conducted by a police officer into any offence alleged to have been committed by a public servant under the PC Act without prior approval from appropriate authority. However, neither it is said that private person cannot request for the prior approval from the competent authority, nor only the investigating agency will seek the sanction from the competent authority. The only thing is to understood that the police will not inquire without prior sanction. It is important that police should start the investigation process only after getting the sanction from the competent authority. It is immaterial who does the effort to get the sanction. The decision of the Honorable High Court of Karnataka in so-and-so, Dr. Ashok, my lord's judgment.
Yes.
What more application of mind can a governor, my lord, make? He is expected to make at a 17A stage. But since it was a contention raised by the Honorable Chief Minister, he deals with this. So-and-so and various high courts, the High Court of Karnataka had issued guidelines to be followed in the cases related to prosecution of public servant for the alleged offences during the discharge of duties with a circular dated so-and-so. This circular stipulates the procedure and prerequisite for registering the cases of prosecution against the public servants. Point number 2 of the circular reads as, my lord, your lordships have read that circular, I'm not, my lord, reading. Hence, last 2 lines, the above circular of the Honorable High Court makes it compulsory that previous sanction is necessary to file a private complaint in the court of law by private persons. In view of the aforesaid, it emerges that the present situation amounts to peril of democratic principles and therefore requires independent application of mind and my subjective satisfaction and objective assessment of facts and materials provided. Since the sanction is sought against the Honorable Minister himself, Chief Minister himself, the surrounding circumstances of placing the show cause notice before the Cabinet and the decision of the Cabinet advising me to withdraw the notice would not inspire confidence to act on such advice of the Cabinet. So why he is not following 163, my lord, is also recorded by applying mind. Upon perusal of the petition along with the material in support of the allegations in the petition and subsequent reply of Shri so-and-so and the advice of the State Cabinet, along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that allegations and supporting materials disclose commission of the offences. Then, my lord, at the end, he says 32. Hence, I hereby accord sanction against the Chief Minister under Section 17A of the Act, read with 218 of so-and-so for the commission of the alleged offences as mentioned in the petitions. My lord, petition mentioned two things, 17A and 218. 218 is 197.
97.
My lord, which is not the stage here.
Yes.
So this will have to be confined to 17.
197 is pre-cognizance
So
sanction.
pre-cognizance after investigation. my lord.
Investigation.
And, my lord, thereafter, my lord, the order is passed based upon, my lord, this material, which is on, my lord, page 1. Your lordships were taken by my learned friend, Mr. Singhvi, to the order, my lord.
The order?
Well, the impugn order. Impugn order, my lord, but this is the impugn order, my lord, thereafter according sanction to court. And, my lord, this is the Honorable Governor signs on 16th August 24, the entire
Yes.
detailed, my lord, consideration. And on the same date, on 16th August, the impugn order is passed according approval. And I'll show that all findings, all considerations, all application of mind need not be in the order. It should be reflected on file, and the court's conscience should be satisfied that there is an application of mind. My lord, when I am meeting with the allegation that the Honorable Governor did not apply mind, my lord, let me show something very interesting. The application of mind and why the Honorable Governor was fully justified in not relying upon the aid and advice. My lord, there are 5 stages. My lord, I'll just tell your lordship broadly and just, my lord, show. The first is the Chief Secretary prepares a note that these are the facts of the case, say 40 pages. My lord, I'm giving an hypothetical, it would be 45 or whatever.
Yes.
Or 20 or whatever. My lord. Thereafter, matter goes to the learned Advocate General for his opinion. The learned Advocate General, my lord, obviously takes those facts as they are. I'll not say copy because we always, my lord, take the facts as given to us, my lord, from the officers. Then adds his opinion, judgments, etc., etc. That is the second stage. Third stage, the matter is placed before the Cabinet. Cabinet, in this 90-page Cabinet note, verbatim, with comma full stop, reproduces the opinion
Of the Advocate General.
of the Advocate General and the Chief Secretary. Verbatim, comma, full stop. My lord, constitutionally speaking, the Cabinet is collectively responsible, but this is a case of collective non-application of mind. Everyone, my lord, agreed to something which is pre-written, page to page. Thereafter, my lord, the fourth stage comes, and fourth stage is the reply given by the Honorable Chief Minister, which is cut paste from Chief Secretary, Learned Advocate General, Cabinet note, That forms part of his reply. And the last para, that in view of this, don't grant sanction. And the fifth stage, the petition contains those averments in that order, seriatim, page by page. My lord, irony, Bangalore is an IT capital of the country. There is an artificial intelligence available. They could have used artificial intelligence to at least paraphrase what is being copied. But, my lord, they say on a lighter side that artificial intelligence can never match natural stupidity. But this is, my lord, the collective non-application of mind, my lord, and I have dealt with, my lord, a reasonable
Yes.
application of mind by the, my lord.
This is the first
Constitution.
point,
Yes, lord. This is my
application
first
of mind.
Yes. Lord.
No, I think even natural justice you dealt with or still to tell?
Yeah, no, my lord, I have something more
Yes.
to add, my lord. Lord, please come to page of my note, my lord. Please come to Lord, page 19, page 18, because my learned friend may. Lordship may go. Give me
80.
only a minute.
Yes, yes.
My lord, my learned friend may raise a ground, a potential submission which I may deal with right now, that whatever is the application of mind should be reflected in the order itself, and you cannot justify it by file notings. The Honorable Supreme Court had an occasions to deal with such a submission.
Nambudri Park,
Yes, my lord, not required. And
1990,
yes, I'm grateful, my lord.
where the
Kindly
Supreme
have a
Court
look
says if the reasons are found in the file notings, that would suffice.
Enough.
Because it was also a case of a chief minister.
Yes, my lord. Kindly, my lord, have a look at, but just to give a flavor of that judgment,
Have the
page
judgment?
18, my lords.
Have the judgment?
No, my lord, page 18 of my note, I have quoted the relevant part.
Yes, sir.
Page 19, my lord, is the judgment, para 22.
E.G. Nambudri, yes.
Yes, A.G. Nambudri, my lord. It is submitted that in order to understand the reasoning of the decision to grant approval for sanction, the perusal of, this was also grant of sanction, pre-cognizance section. So something at a higher threshold.
After
Then-
investigation.
Yes, after investigation, 17A is at a much lower threshold. The perusal of the file is necessary. It is stated that same is a permissible mode of examination of the extent of application of mind and locating the actual reasons behind the order. In case of Union of India versus E.G. Nambudri, my lord, please turn the page over, my lord. I'll read, my lord, only what is relevant, because I know, my lord, your lordships need not be bothered with what is, my lord, very obvious. Your lordships are fully aware, but only highlighted part. If any challenge is made to the validity of an order on the ground of it being arbitrary or mala fide, it is always open to the authority concerned to place reasons before the court which may have persuaded it to pass the orders. Such reasons must already exist on record, as it is not permissible to the authority to support the order by reasons not contained in the records. Like my lord Mohinder Singh Gill case, that you cannot substantiate your order by filing affidavit subsequently. But the reasons are already
So
pre-existing.
the submission is in Mohinder Singh Gill, there was nothing in the order nor in
Order?
the file. It was sought to be justified by way of statement of objections, which the Supreme Court said it cannot be done.
It cannot be done.
Now what you're saying is that everything is in the file.
File.
It is not that it should be in the order.
It existed when the order was passed.
Existed.
Then para 10. In governmental functioning, before any order is issued, the matter is generally considered at various levels and the reasons and opinions are contained in the notes on the file. The reasons contained in the file enable the competent authority to formulate its opinion. If the order as communicated to the government servant rejecting the representation does not contain any reasons, the order cannot be held to be bad in law. If such an order is challenged in a court of law, it is always open to the competent authority to place the reasons before the court which may have led to the rejection of the representation. It is always open to an administrative authority to produce evidence, elucidate before the court to justify its action. I cannot file an affidavit and supplement it by new reasons, but I can always show that reasons already existed. And summary of those reasons is
Forms the part of the order.
forms part of the impugn order. My lord, similar in case of my lord Sarath Kumar Das. My lord, kindly see only the highlighted part. The record is called to consider whether he has given due consideration to the facts placed before him before he arrives at the decision. Therefore, the reasons in the order or found from the record bridges the link between the maker of the order and the order itself or decision. Therefore, the natural justice is not a rigid nor an inflexible rule. It should be applied to a given fact situation depending upon the background of the statutory provisions, nature of the right which may be affected, and the consequences that may entail. This court held that the grading itself is a reason and no separate reason in that behalf in arrangement, or that is on the facts of the case. So, my lord, it is not providing reason post decision, but showing
Reasons
something
existing
pre-decision. Then, my lord, page 22, I have quoted, my lord, again Sri Rupa. Lord, where only para 30 and 31, my lord, may perhaps, my lord, I would
Yes,
like to assist your lordship with.
Yes, sir.
It is therefore not necessary that there should be clear incriminating evidence with the investigating officer at the stage of him seeking prior approval under 17A. My lord, here was the facts where
There, no,
he
Lokayukta was
started on it.
complaint.
He started on
The
his own.
Lokayukta was, the complaint was made to the Lokayukta. The investigating officer had sought approval under 17A. It is in those circumstances it was written.
All that is required under the provisions of section 17A of the Act is that the investigating officer has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. This is all the complainant needs to do, and this is all the Honorable Governor needs to examine. Look, 31, my lord. Since the public servant is yet to be investigated, the question of considering any incriminating material and coming to the conclusion that an investigation is unnecessary would not really arise in this particular case. Since the public servant is yet to be investigated, the question of considering whether there is any incriminating material or its veracity by the state government to come to the conclusion that an investigation is warranted or not would be untenable and stand no logic or reason. At this stage, it cannot be done. He is yet to be investigated by the Lord. Then page 23, para 49. The argument that the materials collected have to be considered meticulously. My learned friend, my lord, in substance, I am paraphrasing his submission, said that the order granting approval under section 17A should be akin to a judgment of the court, dealing with each and every submission made by the Honorable Chief Minister. No, this is purely an executive administrative order. It need not contain para-wise para, contention-wise contention findings, because that would be counterproductive to the very intent of section 17A. That, my lord, this honorable court says, the argument that the materials collected have to be considered meticulously as indicated by this court in so-and-so cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case where the order of approval merely stated that government had meticulously considered the matter by use of the term so-and-so. Thoroughly checked, my lord.
Thoroughly checked.
Thoroughly checked. The relevant portion of the order reads as follows, my lord. So, my lord, this is a 6-page order. It considers everything. And I am, my lord, showing to your lordships and in my respectful submission, my lord, satisfactorily, that there is an application of mine. My lord, now please come to, my lord, page 24. Para 28, State of Maharashtra versus Ishwar Piraji Kalpatri. My lord, what documents should be scrutinized at the stage of sanction?
Sanction.
This is 19, the sanction under 19, my lord, precognizance. Another reason as given by the High Court for quashing the sanction was that the order of sanction was signed by Additional Chief Secretary to the Government of Maharashtra But there is nothing in this order to indicate as to whether the signatory or any other officer on his part was the one who had personally scrutinized the file and arrived at a subjective satisfaction that is a legal prerequisite. We do not find any warrant in law which requires a statement being made while according sanction that the officer signing the order had personally scrutinized the file and had arrived at the required satisfaction. They might say that the governor asks someone else to prepare the charts. He can do that, my lord. Any authority can do that. That this kind of clerical exercise of bifurcating in 3 different compartments, you give it to me so that I can easily make up my mind. Then, my lord, para 12. This prima facie shows that there has been an application of mind and that the material on record has been examined by the officers concerned before according sanction. In view of the aforesaid, there was absolutely no justification for the learned judge to observe that any such statement as indicated by him was required to be made in the order. The learned single judge made observations to the effect that the manner in which the sanction order has been passed would show that a rather cavalier treatment has been meted out in the present case. We do not see any justification for the court making such observations in the present case because the perusal of the order of sanction does not show any legal infirmity, etc., my lord. My lord, then on principles of natural justice, my lord, page 25, para 31. My lord, I need not read this.
Celebrated judgment, Ramji.
Yes, my lord. So I know, my lord, your lordship would be aware. I placed it for immediate reference. Your lordship may not have to try and find out, my lord. Therefore, I'm not reading it, my lord.
Para
Even-
13 of that judgment.
Yes, my lord. Yeah, my lord, we have quoted
Truly
that.
horse or
And we have quoted 24, my lord.
24.
Yes.
Para 24.
Ramji, yes, my lord, 13. I'm sorry,
Ah,
your lordship,
yes.
sorry. I'm not, my lord, then, my lord, I'm coming to the next limb, that in administrative action, there is no hearing required. I have already made my submission broadly, that 17A is a stage where a very, very broad and prima facie view is to be taken. Whether it needs investigation, then you have all the remedies. Once the FIR is registered, you have the remedies, and with which the approving authority, approval granting authority is not concerned. At times, it might happen that if an opportunity of hearing is read into the provision, the act, the object, intent, and purpose of the act frustrates. The person might, my lord, destroy the evidence. And in any case, by the very nature of the power under 17A, which is purely executive and administrative in nature, Lord, no hearing is necessary. Lord, for that, my lord, I wish to, my lord, cite Subramaniam Swami, my lord, at page 27, para 36 at the foot, my lord. They have also cited, but, my lord, this is the true ratio which is applicable in the present case, my lord. My lord, in fact, we got very substantial assistance from the judgment compilation filed by them. Para 44 of, my lord, Subramaniam Swami. We may also observe that grant or refusal of sanction is not a quasi-judicial function, and the person for whose prosecution the sanction is sought is not required to be heard by the competent authority before it takes a decision in the matter. This is for 19,
19.
much higher threshold, because the court is taking cognizance.
17A was not there at all.
Was not there at all, my lord, because it was introduced in 19, my lord.
2018.
18, my lord.
Yes.
Yes, I stand corrected. I am obliged. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency, prima facie disclose commission of an offense by a public servant. Well, this deals with the argument that principles of natural justice are attracted at 17A stage. If it does not attract, even at the stage of 19, which is a higher threshold, where the court is taking cognizance, and therefore you are now an accused. Here you are only a suspect at 17A stage. 19 makes you an accused. Even there, you are not supposed to be. It's purely executive function, administrative order. Similarly, my lord, judgment of Deepak Chaudhary, my lord, only para 5, the highlighted part,
Yes, sir.
we find force in the contention. The grant of sanction is only an administrative function. Though it is true that the accused may be saddled with the liability to be prosecuted in a court of law, what is material at that time is that the necessary facts collected during investigation constituting the offense have to be placed before the sanctioning authority, and it has to consider the material. Prima facie, the authority is required to reach the satisfaction that the relevant facts would constitute the offense and then either grant or refuse to grant sanction. The grant of sanction, therefore, being administrative act, the need to provide an opportunity of hearing to the accused before according sanction does not arise. The High Court, therefore, was clearly in error in holding that the order of sanction is vitiated by violation of principles of natural justice. The second ground of departmental exoneration by the disciplinary authority is also not relevant. What is necessary and material is whether the facts collected during the investigation would constitute the offense for which the sanction had been sought for. My lord, similar is Ishwal Piraji Kalpatri, again, my lord, at para 15, page 29, para 15. In our opinion, there is a complete misreading of aforesaid provision by the High Court.
In
It
fact,
is-
in Veeraswamy's judgment, all this is discussed.
Yes, my lord, your lordships are aware, I need not.
91, 3 SCC, I guess.
Yes, my lord, that is K. Veeraswamy, which is
Ah.
cited at para 16, page 30. Lord, your lordships are absolutely right. Page 16, foot at the
Yes,
bottom,
yes.
K. Veeraswamy case, 91, 3.
Because at every stage of the investigation inquiry that is made earlier, so you need not go on questioning the accused or
Yes,
elicit information.
confronting him or etc. etc. It is only when the investigation starts that the investigating agency does it. The approving authority, in fact, should not do it, cannot do it, and is not expected to do it. My lord, other judgments are also, my lord, on the same line.
Yes, sir.
Only one, my lord, judgment, my lord, I would wish to, my lord, place for your lordship's consideration is at page 36. But before that, let me, my lord, give the background.
Yes, sir.
My learned friend, my lord, possibly being aware of the law on the point that even at the stage of sanction to take cognizance, hearing is not read by the Honorable Supreme Court, and Supreme Court has clearly said that no hearing is required. He attempted to come out of that line of judgments by saying that in Rajesh Agarwal, now after reading Maneka Gandhi, etc., the law is that hearing is required. My lord, I had an occasion to assist the court in that judgment, my lord. My learned friend was opposing me. Where, my lord, the facts were, there is an RBI circular. RBI circular provides for various steps to be taken by the banks to find out
Before you declare one as willful defaulter or a fraudulent.
or a
defaulter.
fraudulent defaulter, because I may be in a genuine financial difficulty or I really had an intention to cheat. And the consequences were, if I am declared as a fraud account, then other banks will not lend me no loan. My other accounts would automatically become NPA, etc.
Serious economic consequences.
The court bifurcated its judgment in two categories. A, the civil part of it, that when you declare somebody as a fraud not as understood in the IPC or now BNS, the fraud in the commercial banking sense of the term. And thereafter, there are some civil consequences because you go for statutory audit, you go for forensic audit, there are several things, etc. And therefore, you must associate him, because without which forensic audit is also not possible. Forensic auditors also would need your books of accounts, your vouchers, etc., etc. Therefore, the court said that you must hear him. But the second category, second option in the resolution, in the RBI circular was that this is okay, this is civil part of it, but you can also register an FIR. And the argument was that when it is question of registration of an FIR based on something fraudulent in this banking transaction, I should be heard. Lord, I raised the contention that there is no concept of hearing so far as invoking criminal investigation power is concerned. And my lord, I believe inadvertently my learned friend, my lord, missed that part of the judgment while citing page 36, my lord. Para 42.
Before FIR is lodged and registered.
No opportunity of being heard is required before an FIR is lodged and registered. My lord, we are dealing with 17A, which is a scenario prior to registration of the FIR. So at the stage of FIR also, you are not supposed to be heard. Where is the question of giving a hearing pre-FIR stage, where I am only prima facie considering whether to permit you to register an FIR or not. Well, Lord, this in my respectful submission, in all fairness to the court, ought to have been pointed out while relying upon, my lord, Rajesh Agarwal. Because in fact, I am relying upon it. Now, my lord, page 37, non-supply of other two petitions does not invalidate the order. My lord, I have already said, hearing being not a prerequisite, merely because in one case show cause notice is given, other two cases which are not dealing with any different, distinct or completely a different offense, they are the same. So there is therefore the governor says that give me the comparative chart, whether there is any difference. If one allegation is some defalcation in Mysore and another in Bangalore, with different set of facts, different particulars, different authorities involved, different officials, connivance with different people, beneficiaries are different, then, my lord, maybe he may have.
In fact, the
issue
governor says everything is the same.
is the same.
Same.
So you can't
There is no
take
difference in facts.
Yes, my lord, when the facts are same, then what is I'm posing a question to myself, prejudice cause. Whatever was against you was given to you, though was not required to be given to you. But nonetheless, in all fairness, the Honorable Governor gave it to you. Two other persons have also said the same thing, which you were not given, but your answer is on the same issue, same allegation, same set of facts, same beneficiaries, same documents. Therefore, my lord,
So
there is no
are
prejudice.
Are you going to Karunakar?
I'm going to.
Prejudice.
Yes.
No prejudice.
Yes, my lord. I am. Page 13, I have, my lord, I can't match your lordship's speed, my lords, and knowledge both, my lord. Your lordships are aware, my lord.
94-1074, where Supreme Court says prejudice should be first established. There it was established, is said, because inquiry officer's report, which was against him, was not given.
Was not given.
Pursuant to the 42nd Amendment, that was the interpretation made. That's
Here, my lord, there is no prejudice cause. Even if, my lord, all three complaints were not given to him and no show cause notice and the order of approval would have been passed, it would have, my lord, withstood your lordship's judicial scrutiny. So, my lord, that is the judgment. Another is Haryana Financial Corporation, Kailash Chandra.
And that is following Karunakar.
Yes. My lord, then, my lord, I am on aid and advise at page 41. My lord, kindly read 164. Madam. Page 41.
Page 44.
Page 41, my lord.
Yes, sir.
My lord, while my lord, the proposition is when the Honorable Chief Minister is a potential person to be investigated, the aid and advice of his counsel cannot be, in constitutionally speaking, taken, my lord. And the answer is 164, apart from the judgments. Other provisions as to ministers. The chief minister shall be appointed by the governor, and other ministers shall be appointed by the governor on the on the advice of the chief minister. So I, as a minister, owe my ministership to the Honorable Chief Minister. It's from Caesar's to Caesar's wife. This is one example where without any hesitation, one can reach a conclusion that in this case, the governor cannot even look at the cabinet note. Though he looks at it, examines it, records a finding that I should not rely upon it, both in law and on account of bias, and therefore, my lord, he chooses not to rely upon it. Please see, my lord, the judgment Lord, before that, my lord, kindly see para 55 at the foot, my lord. It is further submitted that in accordance with Karnataka government transaction of business rules, specifically Rule 20 and 28, it cannot be said that the petitioner did not have any influence over the meeting convened to decide whether sanction may be granted against the petitioner. A simple reading of Rule 20 and 28 of the rules would make it clear that the petitioner enjoyed an overarching influence on his cabinet colleagues. Rule 20 reads thus: cases specified in the first schedule to these rules shall be brought before the cabinet after submission to the minister in charge of the department.